It's back to Massachusetts. What are Karen Reed and let's the Justin the Alien into now, Michael Bryant?
Hey, happy, look at the green. Happy St. Patrick's Day, which is also
Happy Holiday was the parade today.
That's right, and also a Boston thing, but that's probably the best thing coming out of Boston. Anyway, and we also have maybe some of this. Any idea what that is?
Justice, where are you? Michael and Linda are here.
Love you, Linda.
The world is justice. Will we ever find justice?
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
Justice when we see it. To be and down, I lead the way. Hoping justice will win the day. It's Nary Clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
Oh, yeah.
Lemon pound cake. Did you make that? You know why? Because this goes to the fact that on Thursday. Oh, by the way, I guess you should do the rip and read, but we're past with the rip and read, aren't we?
Sometimes you just need some lemon pound cake. That's
Cat Not Williams brought this to our attention. This is my favorite trial I've ever seen. We're going to be doing it Thursday. Doug Weinstein will be joining us. Mark Vetero will be joining us. And I understand that angrily lawyer, Jim Robichaud, wants to join us because he's got all the documents. So we may have a blast on Thursday.
And we may have a verdict by then.
We may have a verdict by then too.
The plaintiffs have rested.
Yeah, Afroman.
Even though Afroman was on the stand today out of order because he came on as a plaintiff witness, he is then going to return as a defense witness. He is being sued by 9 cops. I think it's 9.
Yeah,
who say that he defamed them, and it's an outrageous case. Unbelievable.
It's an outrageous case that they're suing him. But anyhow, I just want to quote our friend Joshua Schiffer. He doesn't even know he's being quoted. He called him an absolute hero because he brought the news with him to get his money back from the cops, so he wouldn't get Epsteined.
That's what he did say Epstein. You're talking about it's his testimony. It was just a pleasure.
It was the best. So we're going to be doing that Thursday. This is just a tease because it's simply my favorite. And you know what else? And I'm going to tease this too. He actually, there's this whole issue about Lisa, the police officer. And he actually said, no, she didn't take anything. I feel sorry for her. But, they brought this on themselves by coming to my house. You have to know the story. I mean, we're talking kind of out of turn
when
here.
you talk Lisa Phillips, that cop, the things that were said, and, we're talking about a defamation case here. And it's not a criminal matter. It's a civil matter where a lot of these cases, Aidan Carney, probably belong not in the criminal courts. Think Depp Heard. Defamation can be a viable case. She has a horrible story to tell. It'll be up to the jury of 10. Well, we're getting these weird number juries. Jury of 10 will be figuring this out. Anyway, that's Thursday. I don't know if any of my lemon pound cake will be still available at that time.
Well, we're going to, as a matter of fact, Joyce Mahar, you've been asking us about guests, and we have guests tonight. And Michael DelSignore is sitting in the green room waiting for us. Green room today for St. Patrick's Day. But we're going to give you your first assignment. This is a production meeting. You're going to call the attorney or email the attorney for Afroman and see when he'll come on our show Thursday night.
Dave Osborne.
Yeah, he's great. I love him. I love Afroman. See if he'll come on our show Thursday night. After all, high-profile show. Afroman likes high-profile cases. He's appeared with Snoop Dogg. I can't wait. All right, that was actually my main rip and read, but there was really more than a rip and read.
Okay.
Missy's going to help you, by the way. All right, so you want to go to my second rip and read?
Yeah, go ahead and get those done, and we can move on. We have some audio that we want to play for you before we get to the Karen Reed stuff.
Yeah, this is our friend Lauren Conlon. Tupac murder case twist. She says Keefe D's attorney withdraws. Keefe D, I think he pronounces it.
Sorry. I got rid of Keefe D.
Well, yeah, Keefe D. He's no attorney anymore. I mean, he got an attorney. He was arrested when we were back in Law and Crime, So
this is the guy who did he write a book or he did a documentary in which he sort of kind of confessed to being the lone guy that's still alive that might be connected to the death of Tupac.
Yeah, it's kind of an interesting case. And then let's add this one to the stage. Oh, we have a hand there.
That was
Let's
me.
add
Sorry.
this is our friend Michael Reeves from Mike Reports. He's over at Fox News. He had been out in Arizona for covering the Guthrie case, who they still haven't found, as you know, after all these days and weeks. But Luigi Mangione's defense team filed another letter in the state case to try to suppress the backpack. So even though the federal court case, the backpack is not suppressed, in the state case, this is still ongoing. So let's keep an eye out on that, okay? And today, when we didn't have any rip and read yesterday.
That'll be a shocker, by the way, if that gets suppressed in the state level. But anyway.
It would definitely be a shocker if it gets suppressed, okay? So I'm just going to take that off. Let's see where we're going to go next. Oh, this has to do with our verdict last night when you left for after you left. This is a curious filing. Nate Eaton posted it about an hour and 38 minutes ago, that the defense attorneys requested an attorney be appointed for Lisa Darden, Kouri's mom, I guess, to interview her for the pre-sentence report. I wonder what that is.
What I think it is this is my take on it. It was filed earlier on in the case, just the judge didn't want to sign it and didn't. And it was done in case she testified at trial. She didn't. So I think it was just wrapping up some loose ends. I don't think there's any sort of, wonder what this could be. I think it's a little more, housekeeping than that.
Okay.
Just my take.
And the last one I didn't have a chance to load when we talk about. By the way, the Kouri Richins verdict, 2 hours and 57 minutes. So I guess
Who won the lottery? Who won that?
In our poll, I guess I had under 1 hour. Or did I have under 1 hour, under 2 hours, 3 hours? I guess it's a tie, really, because it's kind of like 3 hours, but it really wasn't 3 hours. So maybe the people that had 2 hours won. And anyhow, the people that won 13% and all. That's you guys.
I'll
were
save
winners.
you some lemon pound cake.
Yeah, I mean, as I called it too. I told you I would go in the jury room and vote immediately guilty, and I think that's what they did, because they even had ordered snacks, dinner in that period of time.
Yeah, they were spoiled. Those guys were spoiled with the food there.
Spoiled. And I got an interesting question from one of our guests that we usually have on, asking, would I have voted guilty all the way through? And I said, yeah. I mean, I thought I had said that all the way through. I thought they made the case. And then when I saw that text about the poison that was right after her husband died, I said, that's it. I'm done. And I'm a defense attorney, and I was.
How long to die under the poison? Oh,
yeah.
Different misspelling. Yeah.
With a different misspelling. And then the final thing, I didn't have time to load, but I do have it in my hand. In Massachusetts, there was an order to disqualify Cosgrove. No, there wasn't. I'm just joshing with you.
Yes, I do have that, or I do have that. Yeah,
okay.
I do. I'm not sure we want to get into it too deeply, but would anybody be shocked if there was a recusal motion to get rid of Cosgrove that was granted? Anybody think that? Oh, that's not mine. That's yours, isn't it? Yeah. That's.
Can
you get yours there out of the way?
I get mine out of mine.
Can you pull yours off the?
If I can find it. There you go. You got it.
There we go.
Okay.
Yeah. So anyway, the judge has issued the order. You know, those who remember, there was a full-throated hearing on the recusal motion. This was to be done before the big motion to dismiss, which of course has been moved. We'll get to that in a second. So there it is. Just read the big word: denied. And the judge goes in, to great lengths to cover his ass on this. I really think he's looked at this case, lack of merit, thinks that it's going to be resolved by trial. Let's just steam forward with this thing. If, of course, there is a conviction at trial, this will be one of the key appellate grounds. We know that. But I think this judge is like, this case is bullshit. Let's move forward. Let's get it tried. Let's get to a verdict, and then this will be moot.
And I have to mention that Aidan Carney is my client in one of the New Jersey cases, and we do have Mark Betterow coming on Thursday night for Afroman. Maybe we could sneak in a question there. Quite frankly, I think he's better off with Cosgrove being the trial attorney. Who would you rather try a case against, Robert Cosgrove or Alan Jackson or me? Yeah. All right, think about it.
Or even Hank Brennan.
Or even Hank Brennan, right.
That'd be fun. Anyway, so they did move. Remember, March 27th was going to be the day of the big motion to dismiss.
Right.
That's been pushed now to May 14th. And the reason is because the Kelsey trial beginning on Monday, Tim Bradel, Aidan Carney in that case, Tim Bradel, they could overlap. We have no idea now. That three-day trial has become maybe 2 weeks, if you believe the judge's temporary scheduling. So they just don't want that to slam up against that hearing and create yet another problem. So it's been pushed down the road. How many times now? Why not another? Let's just kick it down the road one more time.
Yeah. So, I mean, that's where we are. So those were our rip and reads without the rip and read, which would take time for us to do because we have so much we're going to do. Hi, Jonathan Meaner. I see you in our chat. Welcome again. All right. So we have
so now we have some Kelsey Fitzsimmons stuff that we want to squeeze in here, which is more a tease than an actual subject. But a couple of things. First of all, let me see. I told the folks yesterday we were talking about a text I'd sent to Tim Bradle asking about the possibility of some sort of plea deal because they moved yesterday's updated hearing. It was going to be like, as I call it in California, the go-go, just before trial, last shot, we're going. They moved it to tomorrow. And I thought, well, maybe there's some talk about plea deals. Who knows? So I want to read this to you as I sent it to him in verbatim. Hey, Tim, what are the chances of a plea to misdemeanor offensive touching or simple assault? Has the Commonwealth offered to talk plea? Okay. So he writes back and he says, yes, Michael, there's a chance of a plea if the government pleads to me for forgiveness.
I love you, Tim Bradle.
So there you go. And he did say I could share that. Okay, so just an hour or so ago, I'm listening to Broken Baker, and Marissa, who works with him.
I'm working on a money laundering case, and you're listening to Broken Baker.
Hey, I was eating my cake here, so it all makes perfect sense. So he starts talking about these audios that Marissa, his colleague, has received from the North Andover cops, and they are, we played the parts of Katie and the alien whenever we ran that one someday last week. We had the transcript, which was the only thing that had been released. Marissa said, I think I'll ask for them. And she did. And she got 8 calls that were 2 on the 30th of June, which is the day of, and then a number of them on the 3rd, one of which we played out. And all I can say after having listened to them now is that you were not schmarmy enough, and I wasn't whiny enough. But,
is that what happened? Okay, I can't wait. And again, when we finish this, because this is going to be a tease, because we're going to do a full show on this, right? Yeah. Michael DelSignore is waiting in our green room for St. Patrick's Day.
Thank you, Michael, for your patience.
Jeannie B became a YouTube member. Hi, Jeannie B. Thank you very much. Appreciate it. And we are going to do a members-only show, tomorrow? Is tomorrow Wednesday already?
Yeah, it is. Tomorrow we're going to do members first, and we're going to dig into these audios. Right. Just we're going to treat them like Zapruder films, okay? Forward, back, dissect them. But we have one of them. I want you to just hear one of them because it gives you a real flavor of Justin the Alien, as well as his sister makes an appearance here. Says, I need your help with the cops. Come here. So this 31-year-old guy can't even handle this Q&A with the cop, who's clearly friendly with him. And I've said from day one, they're in cahoots. These cops are friends with the firefighters, and they're willing to help out however they need to. He's getting special favoritism, and these phone calls bear that out. And again, Broken Baker, he just did a show running all of these. Thank you again to him and Marissa. And we're going to get into it in some detail. But let's listen to just the one. Can you hear that?
North Andover Police and Fire calls being recorded.
Hey, this is Justin again. I'm just calling Lieutenant.
Oh, wait, hold on a sec.
I can hear it. I can hear it.
You can hear it good.
Yes.
I did one with subtitling. I'd rather run that one just because, even though the audio
you are a master. Boy, you're a master. I want to let you know that I was able to pull in a live last night with the Kouri Richins verdict. Just so you know, everyone knows.
You might deserve a raise. Okay, let me see if this is. I think this is the right one. Bear with me a second here. I think it's worthwhile to see the subtitling, but it is actually pretty clean. Anyway, yeah. So that was great that you hopped on last night. We're able to do that. I appreciate that.
Sorry about that. I had to reach in to get something off my computer that I needed.
Okay. So again, this would be from. There were 8 calls. A couple of them are just kind of flame outs that aren't really worthwhile because he either hung up, he never answered. It was just odd. One of them, you can hear the baby crying. Of course, I had trouble telling whether it was the 4-month-old baby crying or Justin the Alien. because he sounds pretty whiny. But anyway, here we go.
North Andover Police and Fire call is being recorded.
Hey, this is Justin again. I'm just calling Lieutenant Whitaker back. I just missed his call, unfortunately.
Yeah, Justin, it's me.
Oh, okay. How you doing, sir? I had a couple quick questions for you again.
Yeah.
So she's messaging me telling me that she's planning on taking the baby up to the land in New Hampshire. Do I have any rights to make sure that she does not leave with that child?
At this point, I don't think we do. I've spoken to.
I don't think we do. What the fuck is he
What
talking
if
about?
he's giving him
He's the
legal
cop.
advice? He's a cop. Why is he giving him legal
And why is
advice?
he on the team? Why is he on the team?
The team Justin Alien. Oh,
Yeah.
this is going to be a lot of fun cross-examining. No wonder they're going to have to grovel.
Yeah.
Filled him in on everything that we talked about, and we don't really have the right to deny her child.
Do I have any rights as the father to obtain my child since she's had him for several nights now? Do I have any right to? Hey, this is the custody. We're both parents here. It's almost my turn to have the kid for the night, so I can know that he's safe and I can go file these after.
Now, remember what happened in the night just before this. Hold on. Let me put this in context. This is June 30th, hours before the serving of the temporary restraining order. And that is critical as you hear this conversation between the alien, the cop, and then the alien's sister. Okay, go ahead.
But what I'm saying, because he didn't have the kid for 2 nights, he wants to know whether he can have them so he can file.
And remember, he had moved out. He had moved out, and they had the big brouhaha at the bachelor party. So all of that existed this phone call.
Oh, and we
the
talk.
police
We talk in the future. Also, when you look at this, look at the idea when she gets acquitted, because she is going to get acquitted. This is some 42 UFC 1983 lawsuit here.
Yep. And I tell
Sign
you what,
me up.
It ain't going to help in the family court either.
department, no, we don't have that ability. The only way that you would be able to do that if you spoke directly to her and said, you know, I'd like some time with the baby. And if she agrees to that, great. But it sounds like she's
not
probably not going to be. Yeah.
I have my sister who's
Hey
had a quick question for you as well.
Yeah. I've seen a lot of this, and so I'm on the page of we need to get the baby out of her hands like now, or something really bad could happen. And I know you guys have talked a bit about this, but I am just wondering, is there any difference if she were to try to take the baby out of the state? Does that go against anything? Because that's what she's threatening with. Does the state matter at all? The state lines?
It really doesn't. It's her child.
It doesn't.
You know.
Okay.
Yeah.
One other question for you, because I think, we're talking about going to the courthouse. How do we, and especially because she is a police officer in this town and everyone talks, and I'm just wondering, if we go file this, how do we, because if she finds out that this is filed before it's being addressed, it's going to end really horribly. So how do we actually ensure, and I guess, do you know anything about that process? Would a police officer come with us or with Justin to the house to get the baby? If this is assuming the custody was ordered, that the restraining order and the custody were ordered, what does that look like? Because we're very worried she'd find out before it could actually take place.
Yeah. So if that's the case, then the way, if an order is granted, they will then email a copy of the order to us for service. So we would serve it and then enforce it. So it would be like, here's your restraining order. Per the order, custody of the child is awarded to Justin, in which case we would have to make arrangements, for him to come take the child.
Okay, so he would not be there when you're presenting that. I mean, this might be an obvious question, I guess, because if he has the restraining order, he shouldn't be there.
Probably not. I mean, we should probably take care of that. It's okay if he wants to be close by, in order to take custody of the child quickly.
Yeah, right.
He could come if he's in town. We could then reach out to him and say, okay, she's been served. You can come pick up the child now.
Okay. One, just to, I guess, make sure that, because I know you guys will get notified if there is an emergency order put through. She's an officer, of course. What does she have access to see? I'm just is there a way to flag this directly to, the trusted?
No, when it gets sent to the officer in charge. So
Okay.
nobody sees that except the officer in
Okay.
charge and anyone else who has access to that email, which she does not.
Okay, so that's reassuring. So I'm just trying to make sure there's no chance she could find out before this happened.
Did she catch wind while she was at the police station of anything occurring? Like,
Listen to this.
Nope.
no, okay.
Nope. I didn't want to tip her off and give her the opportunity to do anything rash.
Thank
Okay.
you.
Thank you. All right, officer, I appreciate your time. Thank you.
Very good. Thank you.
So you have what we knew was an issue was why in the hell was he at the house 10 minutes after the service of the TRO? Well, now we know why, because the cops cooperated with them to do that, even though the cop acknowledged, well, he shouldn't be there, and that should be like maybe if he's somewhere nearby after we get the child, then we can arrange that. And that turns into calling him 10 minutes after they get into the home and the confrontation takes place. So more and more of this that you won't believe, and we're going to get into it tomorrow.
Unbelievable. But that's
detail.
since it's going to be members first tomorrow for the other 7 phone calls. This is a good time for me to tell you to subscribe, like, share, notify, and if you wish to become a member for that $2.99 a month, Michael and I try to do a members first at least once a week, sometimes more than that, and hopefully you have contact to us and with us and all. So please subscribe, like, share, notify, and when this ends, hype, but become a member and get the members first.
Yeah, and so we'll do that tomorrow at 4 o'clock. But full disclosure, Broken Baker got this stuff. Thanks, Marissa. They've done it. We don't have a lock on it, but we have our own take, and we will be doing that tomorrow. So I was amazed to hear this guy, in the flesh. I've sort of met him when I antagonized him on the courthouse steps, and he just seems like a mealy-mouthed kind of guy, and this proves it. But as you listen to the rest of these phone calls, you'll hear how what gets him angry. What gets him angry? Any guess? Having to pay for a detail to come and cover his ass at his home. He does not like that. Anyway, because apparently the cops in North Andover are at his beck and call. They're his private security. It's like his own
which that
service.
detail, apparently those visits to his house and his mother's house apparently have stopped after all this publicity.
Yes.
I wonder why shining a light would do that. All right, I have
Good
my viewpoint
idea.
about this. You know that I'm very female friendly on this case, on Kelsey's case. We're very justice friendly on Kelsey's case. As a matter of fact, I think we relabeled, if you will, some of our thumbnails this week, and you'll see them in our Justice Served TV YouTube playlist, because on Wednesday, we're going to be talking about the harm that Justin could have caused this, or probably did cause this child. And we're going to have Judge Ashley Wilcott on, formerly a Court TV host, and Tracy Paul is going to be with us. She's going to talk about the harm to children in another matter, the internet case in California. So we're going to be focusing on the harm caused by children, by adults that should know better.
Yep, and you'll hear little. I hesitate to say his name, but it's out there. But this little 4-month-old, you'll hear while Daddy is pissing and moaning to the cops, you'll hear this baby crying, hunger, dirty diaper, something, but not enough to get Dad's attention. So, anyway, okay, that will be tomorrow. Tonight, we finally had a chance to sort of look into the new Karen Reed amended complaint, and this is the one in which she's finally gotten around to in the federal case, removed by the House defendants to federal court, and now they are adding in the government bad people, right? I mean, we know the cast of characters, Buchanan and Higgins and Proctor and the Canton PD, all of these folks that were involved in what the plaintiffs say, and that's the plaintiff in the federal case, that's Karen Reed, civil rights case, everything they did to basically frame her. So let's do this first. He's been patiently waiting in the wings. Let's bring in Michael. How are you, sir?
Good. How are you doing, Linda? How are you doing, Mike?
Good. We can't get
Nice
away
to
from
see
Karen
you.
Reed. You can't get away from Karen Reed. Nice to see you, Michael.
Yeah, interesting developments with the focus now shifting to the state police, the Canton police. I think she has a strong case against them. She's going to establish that this was an intentional framing of her to get her arrested without probable cause. And based on that intentional conduct, state police will be liable for it. And then she has the fallback claims, negligent hiring, negligent training, which allowed all this to happen, allowed a state police officer to say on his text messages that he was going to pin the case on her without any supervision and all those other texts. And as we saw in the criminal trial, it was essentially approved by his supervisors, and there was no oversight of this, rogue state trooper. So, I think they have a strong case on the civil rights aspect of it.
And as you say that, I'm thinking right to Kelsey Fitzsimmons too. 42 U.S.C. 1983 case that I've tried many times, won many times, when the cops become defendants because they exceed their authority or they're in cahoots with somebody who is a civilian, and then the cop validates what the civilians are doing in such a way that it becomes a conspiracy. It's a great statute. It's my favorite statute in the world.
It is. It is powerful. So should we dive into this document? We're not going to go through the whole thing. Maybe some other time we will, but it's a beast.
Let me just acknowledge some things first before you start, Michael, so we don't interrupt you. Kay Schmidt gifted 5 Justice Serve TV memberships. They're already been given out in the feed. Pay it forward. We don't have any. We don't decide who does that, who gets them. They're given automatically in the feed. You've already got them. They've already been given out. And Karma Dharma 8, thank you very much for that donation. Every time you donate, that helps Michael when he travels for Justice Serve TV, because with the price of gas these days, it's become expensive.
Yes. Yeah. Next week's going to be, I may have to get my residence card.
It's going to be up there. He's going to be up there, Michael. He'll be up near you with you.
That's right. Well, are you near Lawrence or not?
Oh, yes. I'm up in that area.
Okay.
There often. We had another case, actually, that you might be covering where there was an arraignment in Salem. A man was charged with basically burying I think it was his girlfriend for years, and she hadn't been discovered. She was missing for about 8 months, and then he recently apparently confessed, and then he was charged, held without bail, and on the bail argument, they were arguing manslaughter, that he got nervous. But we've had our share of high-profile or strange, cases lately in Massachusetts for sure.
That's people have made a career out of that. Okay, so here we have in the caption the new defendants: Buchanan, Tully, Canton, Higgins. Higgins was in the first one too, I think. Wasn't Higgins in the first one? In the regular, yeah. Okay, so I'm gonna go past these. Are just some fundamental facts that we're all very familiar with, and focus on scrolling alert. Focus on the actions that they're blaming these entities for. Michael, tell us what, if anything, these plaintiffs in this amended complaint had to do against these government entities or people, because they're suing them as individuals in their personal capacity, as opposed to as officers. So explain all of that. How does that work?
So when you sue somebody in their individual capacity, that means they're going to be personally liable for any damages. Now, all these defendants could be found jointly and severally liable. There's conspiracies, allegations, but basically they're trying to say, by suing them in individual capacity, that this is would be potentially a personal judgment against these defendants.
Okay, and jointly and severally means, let's say $1 million is awarded. Each person is responsible for the whole. Not it handcuffs everybody. Even if you're the nth responsible, you're part of the big picture.
Correct. Yes.
Very powerful.
Yeah.
Okay, so in this paragraph, it just says neither Proctor nor any of the MSP troopers conducted physical examinations of the House defendants for evidence of involvement in the altercation, such as marks on their hands, knuckles, or face, or bruises on their bodies. Pretty basic investigation. Even if it's just to rule somebody out. How important is their failure to do something this obvious in a case like this?
I think that's critical, because what she needs to show is that because the criminal trial ended in not guilty, she's established that prosecution ended favorably. Now she has to show that there wasn't even probable cause, that this was essentially a frame job, and the lack of investigation, examination of the evidence certainly is a strong point in her favor to establish that.
And part of the, this whole conspiracy is, Proctor's the key person, but at the very least, supervisors look the other way, if not encouraged and participated. This paragraph talks about Proctor disclosing critical and confidential information about the investigation to his sister, who passed that information to her close friend, Julie Albert, Ryan Albert's sister-in-law. Julie Albert then passed that same info on to the rest of the family and the House defendants. And then there was some talk about a thank you gift. How important is it for the plaintiffs here to link the non-governmental type defendants to the ones just added?
Yeah, I think that's what the plaintiffs are trying to do. They're trying to show that this was a conspiracy. Everyone was acting in concert. The fact that Proctor should not have even been on this case based on conflicts. Those Canton PD had conflicts, and then they basically the police allowed the conspiracy to exist by giving information to essentially what Karen Reed's going to say, the other defendants or the suspects in the case, so they could plan the framing of her for this.
Is every case have a sister who gets confidential information or gets involved in a case? Kelsey Fitzsimmons, Justin Alien, now we're Karen Reed. Same issues.
Yeah.
These are family affairs, it seems. Proctor's supervisors and the MSP knew about, condoned Proctor's unlawful conduct, and in some instances expressed encouragement, this flagrant abuse of power. For example, Yuri Buchanan responded with a thumbs up emoji to a text calling Ms. Reed retarded. All this stuff that we lived through for both trial 1 and trial 2 is now, it's if these were chickens, they'd be coming home to roost, because in the context of the criminal case, it's outrageous, it's outlandish, and in some way confused the jury in the first trial, right? Because they were hung, and probably helped the jury in the second come to the conclusion they did, which was acquittal. Now we're talking about liability for that kind of activity.
Exactly. And now the argument is basically, since this investigation was so corrupted from the start, she basically should have never been charged. She had to spend millions of dollars in attorney's fees. That this case, if they investigated it properly, they wouldn't have brought the charge that there wasn't even probable cause for the arrest. So I don't think she has to show that she was actually innocent for the civil case. The case law says it's enough that the prosecution was terminated in her favor. Obviously, the more she can get to that actual innocence, the better. But I think even short of that, if she can show that there wasn't a probable cause, that had this investigation been done properly, without corruption, bias, without targeting her, she has evidence in the cell phone messages that she wouldn't have faced these charges, then I think she can show her civil rights have been violated.
So, Michael, let me ask you this. No collision. The medical examiner couldn't say a collision. No one brought forth by the prosecution could say there was a collision. How do the defendants get past that if they want to try to now argue again that she actually killed John O'Keefe?
Yeah, I don't think they're going to be able to do it. I think the evidence was substantial. They had a higher burden at the criminal case. Now, with this lower burden of proof, all she has to do is prove this by a preponderance of the evidence. It's a different trial. I suppose they could try to reframe it to a jury and pitch it in a different way. But with that evidence, I think they're going to have a difficult time showing where the probable cause was, when even at the time the medical examiner said this wasn't caused by a car accident. Basically, they just charged her pretty much based on the statements. And then you can attack the statements by saying, well, those people should have been investigated as possible suspects by impartial police officers before rushing to a judgment to charge Karen Reed with this.
And before you go on, Michael, Bryant, with our next, I want to thank the Tall Glass, gifted one Justice Served TV membership, paying it forward, I assume. Thank you very much. And then we have a new member, Ant BB 2370. Welcome.
So, this is kind of it synthesizes everything that was done to point the finger at and frame Ms. Reed, relying on manufactured evidence, actively ignoring exculpatory evidence, and without investigating obvious signs pointing toward the House defendants. The Commonwealth secured 2 separate arrest warrants for Ms. Reed and knowingly baseless indictment against her, and then wrongfully prosecuted her for murder twice. These unlawful acts not only underlie plaintiff's meritless wrongful death claim against Ms. Reed, but they also form the foundation for Ms. Reed's claims against the defendant. As you just said, Michael, this core of operative facts, it's slopping all over everything, from the wrongful death case to now this federal case. These acts violated Ms. Reed's state and federal constitutional rights, the Massachusetts Civil Rights Act, and well-established Massachusetts tort principles. So this case is down federal court. If you were a defendant in the original state action, would you have removed to federal court, and what would have been your motivation to do that?
Typically, yes, I think you probably would remove it. Typically, I think defendants think there's an advantage to being in federal court. It does speed things up. Federal judges, I think, are more inclined to grant summary judgment or to take cases away from the jury. I think the thought process is the jury pool would be broader. I think that would help the defendants if in a specific county, Karen Reed seems to have a lot of support. So the wider the jury pool, I think, the better for the defendants.
I want to point out this one statement, Jeffrey Noble, the colonel, and tell me what you think, because a lot of times pleading is not necessarily what you want to get in or expect to get in. It may be wishful thinking. It may just have some other purpose. So I want your take on how this affects the case. In response to the Commonwealth has offered only empty platitudes instead of solutions. Jeffrey Noble stated, the events of the last 3 years have challenged our department to thoroughly review our actions and take concrete steps to deliver advanced investigative training, ensure appropriate oversight, and enhance accountability. Under my direction as colonel, the state police has and will continue to improve in these regards. This was an interview with the Boston Herald. I'm eyes wide open to a culture issue that I have concerns with as it relates to Trooper Proctor. Oh, really? So, I mean, this reminds me of a product liability type case where you've had remedial measures after the fact, and those cannot be used to blame the defendant in an instant action, because that would chill the remedial actions people might take. That's what this smells like to me. What's your take?
Right. I think that's what they're trying to do. But I think in this case, they probably will get it into evidence. I would frame it as more of an admission of a statement against interest, and he's part of the state police. The complaint, obviously, you only have to provide bare notice of allegations when you write a complaint. This was done, so this gets out into the media. They continue to express their theory of the case to potential jurors, but I think they would get that statement into evidence at trial.
Okay, let me give you another what if. Let's say, because I'm trying to cram this into my civil product liability analysis. Let's say we know there was no body cameras, right? Mm-hmm. But now there are.
Correct, yes.
That's probably not coming in.
I think you could still get that in. They probably would say that, I don't know that that would show negligence, because most departments didn't have them at the time, but certainly I think that could be part of lack of training, lack of oversight. At the time of this case, body cameras were widely used nationwide. Why weren't they used in Massachusetts? And I think this actually, I've been told by lawyers that state police used to actually have body cameras and then they stopped using them. I'm not sure if that, I don't have confirmation of that, but a lawyer that I know respect a lot, he told me that they actually had body cameras at one time. They were losing too many cases and they took them out. So if they can dig up evidence that the state police used to have body cameras, I think that could be part of negligent training.
Wow.
Okay. All right. I tried. I give it a shot. And then as a conclusionary kind of sum up here, they're basically trying to refocus on Mr. O'Keefe. Mr. O'Keefe nor his family has received justice. His killer or killers still walk free by asserting her claims against MSP, Proctor, his supervisors, the town of Canton, and the House defendants. Ms. Reed seeks at minimum to confront and redress these wrongs and others. More importantly, she seeks to force the Commonwealth to fulfill its duty to stop law enforcement from trampling the innocent to protect their own, which has always been the overriding, I called it the disease that's going on up there, and these cases are merely symptoms. How do you see, in the context of a civil case, federal or state, that can actually happen, or is this just going to, somebody's going to get paid off and this thing's going to go away?
I wouldn't expect this case to settle. I think both sides are entrenched. I think this case, I could see this case going to trial. I'd be surprised if it settled one way or the other. There's always a chance, but I wouldn't. I'd be surprised if there was a settlement. I think this is something that will probably go to trial.
I always find here's where the metal meets the pedal meets the metal, I guess is the way to put it, right?
Or rubber meets the road, or one of those analogies.
The weak find out they're weak, things like that. All of a sudden, you have to have because you're about to go to trial. In depositions, you have to have your own independent counsel that's no longer being paid for by the state. All right, because you now have to have personal counsel because there's a likelihood that you will be liable for punitive damages. And as soon as that happens, and you have to give a $100,000 retainer, and you're no longer being covered, and your whole everything that you own, including everything that you try to hide, could be taken by Karen Reed if she wins. Then there's some negotiation for settlement, but that doesn't occur until a long way down the road, and people have had to pay out a lot of money out of their pockets, and usually cops don't like to do that.
Right.
What do you think, Michael, about, and here's the reference I made earlier to each person being sued in their personal capacity. Unions, cop unions, do they provide legal assistance? Would it come from that as a first source?
They may have some kind of insurance that might cover lawsuit acting in the scope of their employment. I would think there'd be some kind of coverage for that, but this, so I would assume there will be coverage based on their role as part of the union. I don't think they'll have to pay this out of pocket.
And tell me if I'm wrong here. I've never worked with unions in that context, but insurance companies, whenever they do cover, always do it under a reservation of rights because they want to cut you loose as quickly as possible and even try to recoup money they've spent on you. I could see with allegations like this, there will be opportunities to cut these defendants loose.
Right, intentional is once you have an intentional wrongdoing. Remember, this is they'll cover them as long as it looks negligent. But once you have intentional and once you have punitives, that's when you have that conflict of interest. That's why these defendants are going to need personal individual counsel at some point. That is above and beyond the personal individual counsel that's paid for either by the town or by the union.
Okay, I'm just trying to hit some of the high points here. While we've got the Brain Trust from Massachusetts. Let's see. This was a highly contested issue in the trials, and it gave both sides something to argue about. According to O'Keefe's Apple Health data, his final steps covered just enough distance to get from the foot of the driveway and into the house or the garage. We know their argument is the dog attacked. There was a fight. It was in the garage. There were sharp-edged or blunt-edged stairs or other objects. John O'Keefe fell back on that. That's where the gash on the back of his head came from. And then the prosecution was suggesting that those final steps were, I don't know, meandering around,
right,
walking in a circle, anything but moving toward the house, basically. This is such an important fact that is so contested and so disputed, and we've seen it torn apart from all these different scientific angles. Do you see any new way to do that in the context of this case?
I think what they'll try to do with all the depositions, they may have a new way to frame the issue. Taking depositions of everybody in the house may shed some new light on, it may be able to, they might be able to explain the Apple Health data in a new way once they take depositions of everybody, because that wasn't, as you both know, in a criminal case, you don't really have the opportunity to take depositions in Massachusetts. So to have someone under oath where you can ask them questions for 2 hours, ask them, where the dog was, what happened when they went in, who was in the house, where everyone was positioned, what everyone was doing, who was saying what, and just to basically be able to question everybody at the same time. There's going to be new information that they're going to learn that may change the complexion of the case in ways that we didn't anticipate.
And maybe we'll find out what happened to Chloe. That would be great. Chloe could make a special appearance. Think we'll have dog bite experts in this?
I would expect probably the same experts in the case. I think they'll present, given, I think both sides, I think, are comfortable with their approach. Now they handled the case the first time out. Maybe there'll be an effort to, answer that question about what happened to the dog. I think the depositions will certainly reveal, we would get that answer if we could depose the owners, the homeowners. We can ask them what they did with the dog, when, and then, always accept their answer. That, it could be that the demeanor during cross-examination reveals that what they're saying doesn't make any sense, and that could be used in the civil case.
And this paragraph really just goes through what I suggested, which is their position on what happened. The dog attacked. There's some sort of altercation. He falls backwards, hits his head, and then they drag him outside and drop him on the lawn. There is the issue with the Ford Edge that was by their take, by the plaintiff's take in this case, was parked in a way to cover for where John O'Keefe was left lying on the lawn. But it's a real fuzzy part of the story, in my opinion. What do you think they can do to reinforce that? Because I think it's an important part of the cover-up, literally and physically, but I think it wasn't all that clear in either trial.
The position, you mean the position of the Ford when Karen Reed was allegedly dropping him off, having a conversation before he went?
No, that the Ford Edge that one of the kids owned, was supposedly parked in an area long after Karen had disappeared in her Lexus, and covered the area where John O'Keefe's body would have been placed, and then later it was moved so that John O'Keefe could be found. That's their story. But I really think the movement of the Ford Edge, who did it, when it was done, is fuzzy.
Right. Yeah, so they will have an opportunity to develop that further with depositions, interrogatories, written and paper discovery.
Well, you called her Chloe. I call her Cora, and she's in Vermont, according to the first.
That's one of the stories.
That's one of the stories, right?
Poor dog, the identity crisis. Let's see. Phone calls, also another big deal here. And of course, we have lots of digital experts in this case, and we've got a few that didn't get to testify that we've had on the show here.
Right.
And so...
and police experts. So our friend, Mike Easter, who we've had on the show a number of times about the lack of proper police procedure, I think is going to be huge when it comes to negligent or negligent training. Right, Michael?
Yeah, I agree. He probably should have been allowed to testify in the criminal trial, but in the civil trial, I think his testimony will certainly be admissible, relevant, and key to the defense on the negligent training and the basically intentional cover-up, lack of proper investigation.
And if you haven't seen Mike Easter, we have a playlist in Justice TV on YouTube, a Mike Easter playlist. He is a fan favorite because he's so brilliant. He's absolutely brilliant. And
his background is digital forensics with the FBI. And so I think, well, and there's also no Judge Bev to keep him from testifying. Right. So that's a plus. So here they're talking about the denial of the existence of phone calls, and the stories told are just so ridiculous. You know, the butt dial stories, when confronted with the existence of these phone calls by a separate law enforcement agent, and I think that's interesting too. We know it's the FBI. Everybody knows it's the FBI. But even in this pleading, they don't say that. What's your take on that?
I think they're just trying to stick with the rules that were established in the first trial. I mean, they don't, in a pleading, it really, the jury doesn't read the pleading anyway. Maybe they're just trying to not offend the judge and abide by the rules from the prior trial out of respect for the court. Okay.
All right. So anyway, this agency, a non-MSP and non-CPD law enforcement agency, at a separate proceeding, they coordinated the same exact lie, falsely claiming the multiple calls, answers, and hangups were just butt dials. However, 5 minutes after the Higgins-Albert call, Ms. McCabe performed her Google search, the famous Google search at 2:27, How's long to die in the cold, misspelling the first word. And we know how contested that was. You know, who was, Linda, you might remember, who was that annoying woman who testified for the prosecution to convince everybody that this was not done at 227. She was so
Right.
smug.
She
was.
Missy will remember her name. She kind of had the headwear.
Yes, she was so
and
happy with herself.
She was
and
a
so,
very, right.
you know,
a very very good friend of the other guy, Ian Wiffleball, as I
yeah, they were quite the team. So, if Michael, if you're defending this case or prosecuting really the other case as well, the wrongful death case, you're not going to rely on those bodies again, are you? Aren't you?
Sorry, Jessica Hyde, our chat.
Jessica Hyde, thank you.
Always count on our chat. Thank you, chat.
Aren't you going elsewhere?
Yeah, I don't think I would try to use the same witnesses for sure. I think if you're defending the case, you're basically saying that you're relying on the statement she made. You're trying to say that they didn't have a reason to set her up. They were friends with her. How would they bring? Yeah, I think their strongest point is how would they know to bring her back to where the body was found? She brought them back. So I think their strongest point is that if they were framing her, they would have had to bring Karen Read back to the location, and she brought them back. So I in my opinion, they should probably stick with that. That's probably their best evidence of that Karen Read did it and was found not guilty, but wasn't framed, and they shouldn't be civilly liable.
Yeah, and this chunk is just what some of the civilians did, which is part of the overall argument that it was just a cover-up. There was a master plan. Ms. Reed and McCabe were then joined by Carrie Roberts. Good old Carrie Roberts. She was the first liar. She was the very first witness to be caught dead-ass lying. And the three of them left the McCabe residence. However, rather than go to 34 Fairview, McCabe directs them to go back to Mr. O'Keefe's home, which is where Karen Read had just left to pick her up. That makes no sense. After the three of them finally go to 34 Fairview, the illogical McCabe-directed route to 34 Fairview was intentional. Why? It allowed the House defendants more time to finish creating the scene and hiding the evidence before Mr. O'Keefe's body was discovered on the Alberts lawn and first responders arrived. This kind of specificity, to me, Michael, helps them because it's tough to make an argument that they didn't provide enough information, to survive some sort of motion to dismiss or strike.
Right. The plaintiffs are definitely attacking that theory that that Karen Read orchestrated everything by confronting that and saying that that's not true. That there was efforts on the House defendants to direct her. I think they're trying to address that point. I think they realize that may be a weakness in their case, and they're addressing it right up front in the complaint.
So I think we've hit most of the high points here. Linda, anything you thought about?
No, I just think that's this is a much easier case for them, I think, because she was acquitted. It's going to be, when, as you know, Michael, when people have to then testify and their own money is on the line, and homeowners insurance may cover a certain amount, maybe there's $1 million, excessive coverage policy, then things become real. And when you have to take a deposition and you're all of a sudden not protected by the government, then things become even realer. And I think at some point, even though they're on to dig their heels and early on, after 2 years of litigation here, you're going to see some movement on some settlement, especially if the federal courts move, and they move cases really quickly when they want to. And in high-profile cases, they will move it quickly. As you know, Michael, right? What's the docket look like up there?
I haven't seen it recently, but they generally federal court cases are going to get to trial much faster than state courts. In state court, the case could drag on for a year and a half. In federal court, I think it's common for these cases to resolve in a year or less.
Yeah, I would imagine that one of the issues is going to be the number of parties, which means discovery could be a bear. And the parties are required to provide the court with a very specific plan. Here's our plan. Here's when the depositions are being taken. And so they can meet those deadlines, and the court doesn't like when they don't. And you better have a pretty damn good reason if you don't.
Don't fool around with federal court. As you know, I won't be here next Monday and Tuesday because I'll be in federal court on Tuesday and I'll be prepping on Monday. You do not fool around. A lot of lawyers ride by the seat of their pants in state court because they think it's going to get adjourned. In federal court, you better be prepared. Having tried a number of cases in federal court, winning them, it's trial by appointment and everything has to be prepared. And there's something called a pretrial memo that goes in that basically you're trying your case in a document beforehand. Everything has to be put down, all the facts, all the evidence and all. And when you get to that point, that's when lawyers don't like to spend the time.
Right.
Because if they miss one thing, the judge isn't going to allow it going into trial.
Yeah,
and
there's
Alan
not a lot of
Jackson's
ambushing going on.
Alan Jackson's team is not going to miss one thing. I can guarantee you that.
Right.
Michael, let me ask you this: in the big scheme of things, this goes to trial. The remedy in general is money. Is there any way to craft a remedy that requires some sort of remedial action on the part of these government entities?
I don't think that the judge would do that. I think it would just be a money damage. I think the amount of the verdict would create the remedy and change the policies of the state police and the Canton police. I don't think the judge would order any change, but I think the money will force any change. And that's usually how the law works, through attorneys making arguments, asserting people's rights. We achieve social justice one person at a time, and we help change the community and make it better for everybody.
Yep. Would you take this case?
Yes,
as
I
a
would.
plaintiff? Okay.
Yeah.
I'd love this case. I think it's so full of landmines for these defendants.
Yes, I love this
Personally and
case.
professionally.
I love this case, and even the Kelsey Fitzsimmons case. Even if she got convicted or something, I love that case.
Yeah. That one is. Let's get your thoughts on that one. We got you, Michael. It's certainly it's a much more. I think it's more outrageous on a personal level, perhaps, but on a punitive level, it's nothing compared to what Karen Reed was facing, and that makes it, I think, more interesting. If you're representing her, you can really hang it out there. You almost have a backstop because the ultimate penalty is relatively minor. Yeah, obviously nobody wants a conviction, but still, you know what I'm saying in terms of how you prepare and present the case.
Yes, she has a great defense. She was going through mental health issues. They come into her home. They kind of there's issues with why they served the order, what was going on, and she was, I think, startled by the situation. Was under a lot of stress. I think they're going to have a mental health expert to show that, and she, her arguments that she was really pointing the gun at herself, not the officer. I think there's certainly reasonable doubt in the case. She didn't go out to do anything wrong. She's in her house. Police come there. I think there's, an abundance of reasonable doubt. I'd have a hard time saying the government met its burden to a moral certainty based on what I've seen and read about the case.
And that's, Michael, remind everybody, because you practiced in Massachusetts, you were with us through the whole Karen Reed trial, that jury charge is one that's moral certainty for a defense attorney. That is just a wonderful charge.
Right. We do have a great jury charge. The jury's told that even if you find it's a strong probability, that's not enough. So our jury instruction is it's got to be an abiding conviction to a near moral certainty. So really hard to reach that based on what I've heard in the news about the case when I've read. So
with that in mind, and you're representing Kelsey Fitzsimmons, do you put her on the stand?
I don't think she needs to testify. Certainly, you always have to prepare your clients their choice. If she wanted to, she can. But I don't think the government has enough evidence based on their case in chief. So I don't think she'll need to testify. But that'll be a decision, her lawyers will have to make and she'll have to decide on.
Yeah. I mean, from my experience with her, she's dying to tell her story, but that may not be the smartest move. So we'll see how it plays out. So I'll be hanging out in your hood there next week, there, Michael.
Yes.
Yeah, please keep him company since I won't be around Monday and Tuesday.
Yeah, I may reach out.
Yes.
If you're going to be around. We may have some debriefing to do after jury selection. Who knows? We thought it was going to be meaning the parties led us to believe it was going to be a 3-day trial, including jury selection.
Okay.
Now the judge has suggested he's cleared all the way through April 3rd, 2 full weeks.
In other words,
He's-
2
he's-
weeks. There was 15 days in the Kouri Richins case. This judge is planning on 2 weeks in the Kelsey Simmons case.
He thinks it could take twice as long to pick the jury as to try the case. So
Oh.
that's who knows how it's going to unfold. You know, these things. It's a crapshoot. What would be the normal in a case of this type? You know, I know every judge is different, but normal number of alternates.
They usually do 4 alternates in Superior Court, but they can do more. I think Karen Reed's those 6 to 8 at least. But the judge can have more or less alternates depending on what they think is appropriate.
And they have a formula of some sort for peremptory challenges as well, right? Depending on the number of charges and parties, and what would that normally look like? 1 defendant, 1 charge.
So both the defendant and the Commonwealth will get same amount of peremptory challenges. For the charge, I want to say she'll get 4 peremptory challenges, but I'm not. Usually in district court you get 2 preemptories, but I believe in Superior Court she would get 4.
Yeah, I think there's a base of 4, and then I think don't you guys do some adjustment for the number of alternates depending on the number of alternates, something like that, some weird formula for that?
No, I don't think the
No.
offer will affect the number of peremptory challenges.
Okay. All right. Well, we'll see how it plays out in front of Judge Karp. Yeah, he seems like a decent dude. We'll see. We'll see what happens. Speaking of decent dudes, Michael, thank you. Always
Thank you,
always
Michael.
a pleasure to have you on.
Nice
and,
to see you both.
Get
Nice to
the
see you both.
local flavor.
All right.
All
I
right.
really appreciate it. Thank you.
All right. See you.
Take
see
care,
you both.
bud.
Take care.
Well,
Okay, so
that was great.
yeah, I mean, it's always nice to the guy. It's his backyard, so it's always nice.
That's right, right. And he was so
run
great. And
past
Karen
him.
Reed, he explained everything to us. As you know, I met Michael. He invited me to lecture to his group of students of lawyers that he actually pays for to teach them and all. After I did the Hernandez case, and that's how I met him. And he really puts his own personal money where his lawyer's license is to try to train lawyers how to try a very good case. And I was so impressed with him. And then we've been using him on our show.
Yes, we've
because
been
he's so
using him and
impressive.
abusing him. We've been
abusing for Michael.
Yes. I remember that one
But
day.
I did tell him that he would have to stay in the green room for a while. That we would be
Yes.
doing other things.
I remember that one day during Karen Reed where I was out doing stuff, and it might have been during Verdict Justice Watch. He was on like 6 hours or something,
I know,
right?
He was. Yes, he came on at the because these things happened. You know, just like last night with Kouri Richins. All of a sudden, they just happen. You know, and you have to be prepared to be on the air.
Yeah.
And he was always gracious enough to do that.
Yep, that was nice. And I may reach out next week. Who knows? We're not sure what the hell's going to happen next week. Going up there early Monday morning. They'll begin jury selection. I asked Tim Bradle again. I said, look, this is just a scheduling question for my own personal selfishness. Are you really going to ask for a bench trial? Because obviously, if he does, this thing is done in 3 days because they're going right to it. Hey, everything's on the table. So he wouldn't crack. That was his answer last week as well. Everything's on the table. Well, I'm just asking what's really on the table. Come on. You know, come on, tell me. You know, he would not. So anyway.
He's a good lawyer. He's a good
he
lawyer.
is.
Anyhow, please hit that subscribe, like, share, notify button. We've been told that if everybody who's watching likes us, like that is like, you know, 500 people, all once, just all you got to do is hit that like button. That really gets us into the algorithm. You know, our guests donate their time. Our mods here are great. We've given Sheila, we surprised her by giving her duties, more duties, and this is going to help her with. Sheila and Joyce Mahar, who both had these, both share. You can all share. I mean, everyone can help. I mean, help out. Help a little channel out so that we can give you the best programming available.
Yeah, we are the best kept secret in true crime. Tomorrow at 4 o'clock, a member only. We're going to tear into all of these audio clips and give you our spin on that, forward, back, legal, and all practical. I think they're outrageous, and if there's ever been an interest in what was happening before the incident, it is this short period of time. And thanks again to Broken Baker and Marissa for wrangling those audios. We're going to get into them tomorrow. 4 o'clock. Set your alarm there.
And then tomorrow night, we have Tracy Poles, who's going to talk to us about the case in California, the internet addiction case. Our focus will be on children, and we're going to have Judge Ashley Wilcott about the harm that Justin and obviously his family, because we hear his sister, may have caused baby Caden by pulling a breastfeeding mother out of, hello there, Domino.
What does Domino want?
You know, the cake, you know, out of the mother's hands at the time of growth, and that's so important, attachment that's so important. Let's see whether you really have the best interest of the kid when you were collaborating with and conspiring with the police department. Boy, if I'm Tim Bradle, I can't wait for all this.
And you know, he's had these audio tapes for a while himself. Obviously, he referenced one of them when the prosecution suggested that, hey, Justin the alien called the cops ahead of time, so it was fine. Like it was, you know, they gave him a Dominic, they blessed him. Well, then of course we saw the transcript, and tomorrow we're going to hear the rest of the audio. It wasn't quite like that. And when you hear Katie, you know, I know your recitation was very good, award winning. When you hear the real Katie, oh my God, if she went further to kiss his ass, I don't know how it would have happened. It was just nauseating.
Okay. So in other words, take your Mylanta before you come watch.
Yes. So like I said,
you are a member, right?
You were not schmarmy enough for her, and I was definitely not whiny enough for the alien. So
and
we'll get into all that stuff.
And then Thursday, of course, we will be what should I say? Doing Afroman, very important. We already have Doug Weinstein, Mark Betterow, and Jim Roberts.
Everybody wants
joining us. Everyone wants
a piece of Afroman.
Everyone wants a
and that thing. You know, we very likely, I think, will be talking about a verdict by then as well. So.
Yes, I do too. So we can't wait. That's going to be an interesting day. And on Friday, we will have a premiering at 6 p.m. We'll let you know exactly what that's about.
All righty then. Thank you, everybody. Appreciate it. And you've done all the things Linda has suggested, the liking, the subscribing, the hyping, you have to hype later. And what was the other one I missed? Comment, share. All right. And have a great evening. All right. This is Justice Served TV. Thank you. And please try to do the right thing.
Riding flames, they charge with mine.